Hello, everyone, and welcome. Good afternoon to all participants joining us from Austria, and good morning to those joining us from the United States. My name is Thomas Moschig, and I'm the Trade Commissioner at our Washington, D.C. office, and I will be glad to be your host today. I'm very pleased that you are joining us today for this flash webinar on refunds. Flash webinars are shorter versions of our regular webinars. We usually organize them with a short notice and when important or urgent topics come up, which is quite regularly the case here in Washington, D.C., so to say. And the flash webinars, such as today's session, they aim for like 30 minutes. So we will last about 30 minutes today. And our experts will give an overview of today's most important topic, which is the question on refunds. And if time allows, we will then address the most relevant questions from the audience. So please feel free to post your questions in the chat anytime, also during the presentation. And you can also give a thumbs up to questions that you find particularly interesting or relevant for your business. This helps us in identifying the questions that are most relevant for the larger audience. Yes, as I said, today's topic is refunds following the Supreme Court ruling from February this year. And we will focus on the questions: who is eligible, what should be considered, and also how should Austrian companies proceed. And with that, let's get started. Before I introduce our expert of today, let me also briefly mention that today's webinar is being recorded. The recording as well as the slides will be shared after this webinar in the course of this week. So all the registered participants, they will receive all the documents from this webinar today. Yes, and having said that, it's time to, and my great pleasure also to introduce our speaker and our star of today, which is Mark Segrist. Welcome, Mark. Mark Segrist is a partner and member of the advisory committee at Sandler, Travis & Rosenberg. His practice focuses on international trade and customs law, including tariff classification, penalty mitigation, protests, trade agreements, and qualification under preference programs, and many, many more. Mark is a well-known and outspoken trade policy expert and is closely following the current refund processes. And this is why I'm very happy to have him on board. Welcome, Mark. Thank you that you joined us today from Europe, as far as I understood it. Thank you for taking the time to be with us Austrians today. And thank you for also even interrupting your holidays for coordinating and holding this webinar for us. We're extremely grateful to have you for this discussion today. Thank you very much, and the stage is yours.
Thank you very much, Tomas. Really appreciate it. And thank you, everyone, for joining. As Tomas mentioned, my name is Mark Segrist, and I'm a partner at Sandler, Travis & Rosenberg. And today, Tomas, I'm trying to see if I can click through here. There we go. It seems to be working. Today, the title of the presentation is IEEPA Refunds and a Litigation Update. It ain't over until it's over is an expression in English, basically saying you have to wait until the very end to know what the outcome is, and that nothing is really certain just yet. So I am going to be going through some of this relatively quickly. There is a lot to cover, but I want to get through some of the historical information first so everybody understands kind of where we are coming from in terms of this refund process. So in terms of a quick overview, I want to first start with just a current status of the refund litigation at the Court of International Trade in New York. I will also talk a little bit about U.S. Customs and Border Protection's, or CBP's, latest status report on their CAPE system. I'll talk a little bit about protests, which are kind of the administrative process that you go through normally to file for refunds or challenge an entry with customs. We'll talk a little bit about the steps that you can take to protect refund eligibility, and then obviously want to leave some time for questions at the end, because I think that will be most helpful for everyone. Okay, so as Tomas mentioned very briefly, in February of 2025, so February 1st of 2025, President Trump, that was the first time he used the IEEPA statute, the International Emergency Economic Powers Act statute, to impose a variety of different types of tariffs as an emergency on goods coming into the United States. And that was everything from what are known as like the fentanyl border tariffs, China fentanyl tariffs, Brazil oil tariffs, as well as India tariffs for purchasing Russian oil. So all of those, the details of those specific tariffs aren't as relevant right now, but all of them were imposed using the legislative tool of IEEPA that the president kind of thought he had at his disposal. That obviously was challenged in the United States and went to court, went all the way up to the Supreme Court of the United States, at which point the Supreme Court ruled that the president does not have the authority to impose tariffs under the International Emergency Economic Powers Act. It does give the president the authority to regulate foreign commerce, but that does not mean tax. And one of the reasons there is constitutional in the sense that the power to tax and to spend is really something that lays with Congress under our Constitution. And so the court said, look, he can regulate international trade or foreign commerce under this statute, meaning stop shipments potentially for security reasons, but he can't tax them. And again, this was a statute going back to 1977, and no president had used it since President Trump had. So what does the Supreme Court decision mean? It means that the president never had the authority to impose tariffs under IEEPA. So that would cover, again, the Russian oil tariffs, the India oil tariffs, the China fentanyl tariffs, the border tariffs, and the reciprocal tariffs that kind of every country had their own individual rate. So basically what this means is that none of those tariffs were lawful and as a result are in the process of being refunded. So the Supreme Court remanded the case back to lower courts, which is the Court of Appeals for the Federal Circuit in DC, and then down to the Court of International Trade, or the CIT, where all the action is really happening now with respect to refund claims and all sorts of things that I'll talk about shortly. But basically all future challenges have to go back to the Court of International Trade, not to the Supreme Court, obviously. So we've talked a little bit about what the Supreme Court decision did, but what did it not do? What it did not address was how refunds should be processed, right? The court kind of took a really narrow position here and said, look, we're just going to opine on the issue of whether the president had the legal authority to impose tariffs under IEEPA, but we are not going to get into the weeds and into the details of how refunds should be processed. That's something that's up for customs and the administrative agencies to figure out. So that's kind of where we are today. But it also did not decide whether a concept known as de minimis or Section 321 informal low value shipments was lawful. That's being handled by a separate case, Detroit Axle case. It also did not decide whether other tariffs were lawful. There has been, since a court challenge on the Section 122 10% tariffs that were imposed when these IEEPA tariffs were struck down. We're waiting for a decision there. The Section 301 tariffs, for instance, from Trump's first term against China, those are still in place and those are still being litigated today. So this Supreme Court decision was very narrow. It was focused just on the president's use of IEEPA authority to impose tariffs, which it ultimately ruled he did not have. There's been a lot of activity at the Court of International Trade since this case has been brought back down from the Supreme Court. I'm not going to go into all the details of this right now. You will get a copy of these slides, so hopefully that will be helpful. But the two dates that I wanted you to focus on right now that I think are important for us is March 4th. The first one, which it says the Court of International Trade, Judge Eaton issued a ruling in the then Atmos filtration case that CBP must immediately refund the IEEPA tariffs. And since that time, there's been filings and motions and back and forth and kind of expanding the scope of the motion and narrowing it back down again. The Atmos filtration case has been voluntarily dismissed by the plaintiffs, and a new case has kind of come into its place called Euro Notions. But at the end of this process, the goal was that Judge Eaton was instructing Customs to develop a process to figure out how to refund these tariffs. And so Customs has come up with this process known as CAPE, or the Consolidated Administration and Processing of Entries, CAPE as the acronym. And phase one was deployed just about a week ago on April 20th. And companies are now in the process of actually making their CAPE submissions to get refunds back. So we'll talk about that a little bit more. But those are really kind of the two dates that you need to know. But there has been quite a lot of activity since then. And this is just the declaration from the executive director at Customs, Brandon Lord, where he was saying, hey, I understand what our role is. I understand what the court decision is. And I understand that we need to develop this CAPE process, where he kind of lays out how that process is going to work and the timeline for doing it, which we'll, again, talk about a little bit here. So now that Customs has developed this CAPE process, they're in phase one of the CAPE process. And so I just want to be clear kind of which bucket we're in right now. The question is which entries are eligible. And I'll talk about this through the presentation, but this is something that I think for many of my European clients is difficult to understand, because this is where these concepts of liquidated or unliquidated, these terms that maybe you're not familiar with, come into play with respect to US entries. So just at a very, very high level, when an entry comes into the United States on day one, for instance, that entry will remain usually open for 314 days. So it's almost about 10 months that entry will remain open, or unliquidated is the term, in Customs' system. So that way, if something happened and you realize there was an error or something needed to be changed, you can actually physically go into the system and you can file post-summary corrections, or PSCs, to correct those entries, because they're not finalized, right? They're not liquidated. They're in their open state still. But let's say that entry liquidates on day 315. That is known as kind of the next step in the process. And at that point, you can no longer make changes to that entry once it has liquidated on day 315, for instance. But that starts another clock, because if you have a challenge to Customs on that entry after it has liquidated, under the statute, which I will talk about, you have 180 days from the date of liquidation to file a protest with US Customs. Otherwise, that entry finally liquidates, which is a different term, meaning there are no more administrative remedies available to you as an importer. You could have filed a post-summary correction when the entry was unliquidated within that first 314 days, or you could have waited for the entry to liquidate and then file a protest with US Customs. And so there are court cases where somebody tries to go to court as a next step, and Customs says, well, you're not eligible to be before the court right now because you did not exhaust your administrative remedies and file a protest within 180 days of liquidation. So there's some slides that talk about this a little bit, but these are the terms that I'm going to be talking about. So hopefully folks can follow along. But which entries are covered under CAPE first and foremost? Entries that are unliquidated. So those are recent entries, right? Those are entries that came in on day one and they are still kind of open in that system. It's usually, depending on the entry type, but usually it's 314 days from the date of entry that entry will remain unliquidated. So those entries, if you look in your ACE system and they are unliquidated, would be eligible for CAPE generally. Another type of entry is eligible, an entry that has liquidated but is within the voluntary reliquidation period that Customs has, which is actually 90 days, but Customs has said they need about 10 days to review the entries. So long story short, you should be able to submit your unliquidated entries, anything that's within 314 days of the date of entry. And then for any entry that is liquidated, you can submit those in CAPE as well, as long as they are within 80 days of the date of liquidation. Those are eligible for CAPE as well. Also, entries that are suspended, their liquidation has been suspended for one reason or another, maybe, given a review of a court case, maybe they've been extended for one reason or another because an importer has requested it, or maybe they're under review by Customs. Those entries will not liquidate until those reviews or the suspension has been lifted. And so I guess you could submit them, but you may receive an error message back from Customs where it says, hey, this entry is under review, and as a result is not going to process a refund until that entry liquidates at the end of the day. So unliquidated entries, liquidated entries within 80 days of the date of liquidation, and then entries that are maybe suspended or extended, you're going to want to watch as well to see when they might be able to be submitted through that CAPE process. Which entries are not eligible? Entries that have flagged for reconciliation. So if you're a company that maybe has transfer price adjustments between a foreign seller and a U.S. importer, maybe they're related parties, maybe you'll participate in the reconciliation program in the U.S. where you flag your entries for value and you come back and change them later. Those entries are not eligible for CAPE phase one right now, because again, the value could change, the duty liability could change, and so it would ultimately skew Customs' calculation. Entries that are designated for drawback. If you've claimed already that money back as a drawback right, you're probably not going to be able to submit that in CAPE right now. Any entry that is covered by a protest. So if you have filed a protest on a particular entry already, you can't submit that in CAPE Phase 1. And then any entries that are not within the ACE system, the automated commercial environment system through ACE, maybe they were paper filed entries by a broker at the port, those would not be eligible in Phase 1 either. And then any entries that are pending liquidation, pending the finalization of them, pursuant to like an anti-dumping or a countervailing duty case, instructions from the Department of Commerce. And that's a lot to kind of take in, but I'll leave you all with those notes, and hopefully those you can kind of sort through your entries and figure out which ones yours are. I already mentioned this. Entries that are suspended or extended or under review won't be eligible until the entry liquidates. And so you're going to have to track those and monitor those a little bit more closely. Now, an important question here is who files the CAPE declaration? So who is the entity that's actually going to be going into the ACE system and making the filing with U.S. Customs? The CAPE rules have been pretty clear that it's supposed to be either the importer of record, so that could be a U.S. company serving as an importer of record, or that could be a Austrian company that kind of steps into the United States to be a non-resident importer of record. But as long as you're an importer of record into the United States for the entry in question, you should be able to file that CAPE declaration, or your designated customs broker who's authorized to kind of file those on your behalf. But your attorney, so unfortunately, or maybe fortunately in this case, we are not allowed as an outside law firm to file inside of the CAPE system. We can obviously advise and give general guidance and interpretive, instruction, but we can't actually make the filing in the system. How long does it take to get a refund? Customs is estimating, and that is italicized for a reason, because it's estimated to be 60 to 90 days total after submission. So 45 days for processing for customs. And then what is customs doing during that time? Well, they're not only trying to figure out how to remove the IEEPA tariffs from those entries in question, but they are also spot checking issues. Maybe you've got unpaid duty liability to customs. They might take that off the top, right? And issue a debit against your refund because you owed them money on past duty liability. Maybe there's classifications that are incorrect and should have been changed for one reason or another. Maybe the valuation is off, or you misdeclared country of origin, or maybe there's other problems with the entries. So I do believe that this administration is very keen on not giving as much money back as maybe they need to. And so they are probably going to be looking for as many reasons to deduct from that amount if those errors are present. And so it's important to kind of, before you submit your CAPE declaration, just check your entries and make sure everything's in order. What about other entries? So we talked about unliquidated entries. We talked about liquidated entries within 80 days of liquidation. Those first two groups, those are eligible for CAPE Phase 1. But what about an entry that's liquidated on, it's liquidated and now it's 81 or 82 or 90 or 100 days past entry or liquidation, excuse me. In those instances, that entry is pretty much going to be finally liquidated if it gets to a point where it's more than 180 days from the date of liquidation. And so our recommendation would be for companies to really track those entries and to consider filing protests. And so I'm going to be talking a lot about that today because, again, I think you're going to want to be filing your entries in CAPE, but you're also going to want to be watching ones that don't necessarily qualify for CAPE Phase 1 right now, because you may need to take additional action, such as filing a protest to preserve your rights to refunds. Here's just a real brief visual chart here to kind of show what companies should be doing. I think first and foremost, you want to make sure you're creating an ACE account and you're linking your bank account information, your ACH information, to that so that you can receive a refund. You want to be filing your CAPE declaration within ACE, uploading the CSV file and listing all the entry numbers in which IEEPA duties have been paid. If there's errors, it's going to kick back out to you. Customs is going to validate that process. Again, if there's errors, those will kick out to you. Customs will do a entry-specific validation. Customs will then remove the IEEPA tariffs, the Chapter 99 HTS codes, and unliquidated entry summaries will be set to liquidate within 45 days of the CAPE declaration date. Refunds are issued, again, estimated within 60 to 90 days following the acceptance of the CAPE declaration, unless there's a compliance concern. So Customs thinks that they can refund about 120 billion of IEEPA tariffs through Cape phase one. But if you have entries that have liquidated, and I really want to stress this, and they are less than 80 days after the date of liquidation, then CAPE might be all you need, right? You might just be able to submit all your entries in CAPE, and hopefully, fingers crossed, those refunds will come. However, there are still many unknowns that we want to make sure importers are prepared to know about. This is a brand new system that tens of thousands of importers as well as customs are using for the very first time. And even if there are no operational issues, there's really no guarantee that you will receive a refund within the time frame that is estimated by customs or in the full amount that you expect to receive. Here's kind of a screenshot of what it looks like when you log into the ACE system for CAPE. You can download the template, you can upload the list of entries that you've got. You do have to acknowledge that all of the information is correct, the HTS codes, the country of origin, the value, all of those good things before you upload that file into the system. Now, will CAPE be the solution to everything? Will it solve all of your problems? We hope so, but we are not sure because the government can still appeal Judge Eaton's April 7th order that granted universal jurisdiction to all importers. The government is opposed generally to universal jurisdiction, which means it applies to everybody, not just the importers who filed at the Court of International Trade. So an appeal may or may not slow the refund process as to some entries. And what's really important from a legal perspective here is that the CAPE system is an independent system that Customs has developed. It is not law. It's an internal agency's program, which we're very hopeful is helpful and solves the problem. But it does not have the force of law because it is not a protest under 19 U.S.C. 1514, and it is not filing of a court suit at the Court of International Trade under 28 U.S.C. 1581A. So filing a CAPE declaration may not protect you from the effects of the finality of liquidation or the failure to sue within the applicable statutory statutes of limitations. So in other words, don't sit on your rights hoping that CAPE phase one or phase two will solve your problems. You need to continue protesting liquidations of entries to preserve your refund rights. Here's just a little visual display of what I talked about. You've got entry kind of on day one, 314 days, give or take, until that entry liquidates. And then you've got that voluntary reliquidation period where Customs can voluntarily go in and change the entry. Those first two buckets are eligible for CAPE, but anything that is past that pretty much 80 days after the date of liquidation, you probably need to be filing a protest, and only a protest can legally prevent the finality of that entry where you would then be precluded from going to court. Yeah, again, just you want to make sure you're protesting after 80 days of liquidation, but before 180 days. If you have protests that you've already filed, should you withdraw them? I would say that if the liquidation is more than 80 days ago, no, because again, that's really your only remedy at this point until a phase two system or the law changes. If it's less than 80 days ago, then you really want to think carefully, and I'd recommend consulting with an expert on that before you withdraw that protest, because what you don't want to do is give up one right for a refund or a claim to obtain another one, right? And hopefully the CAPE process runs itself through and everybody gets their refunds and it's not going to be an issue. But again, we do have clients that their entries have liquidated and are already beyond the protest filing deadline. And so their question is, well, what if I miss my protest filing deadline? What do I do? What if an entry liquidates? What if I didn't get it in CAPE and I can't protest it now because it's more than 180 days after the date of liquidation? Your real only remedy there would be to file a suit at the Court of International Trade, which we're doing for a lot of clients, to protect your rights to refund. You have 2 years from the cause of action, so from the claim accrual to do that. That's really basically saying, going back to the first IEEPA tariff of February 1st of 2025, you would have until January of 2027 effectively to file suit. Would a suit still be necessary? It is potential that a suit could be necessary because the question of whether this is a protestable issue or not, or whether it needs to go to court under a different jurisdictional claim is still open for debate. And so our recommendation is that you are filing protests for anything that is after 80 days after the date of liquidation, and that you're considering filing a Court of International Trade complaint for anything that is beyond that filing deadline window as well. Again, our concern here is that everything that Customs is doing is kind of on the right footing. They're expecting to develop a phase two. They're hoping to develop this process, but none of that is actually legally binding on them, nor is it law. And I know I'm going through this really quickly. I apologize. I see we're very close on time here, so I want to open to questions. But maybe we can stop there and just jump into questions. But I guess before I do that really quickly, there was a slide that kind of just gave people some next steps of things to take away here. Hopefully that works. Yeah, enroll in ACE. You guys should be searching for the automated commercial environment system. Try to get set up with an account, because if us or your customs broker or anybody else is helping you with that CAPE filing, you're going to need access to your ACE data to do that. Check which IEEPA refund amount you should be owed. Get your own data, download it, figure out what you should be owed to make sure that the amount Customs refunds to you actually matches that as well. And then don't let up until the money is in your bank account, because it's not over until it's over, as I said at the beginning of the thing. But I'll stop there and see if we've got questions here.
Yes, thank you very much, Mark. This was very insightful. We have a couple of questions, and probably we don't have time to answer all of them, but for the audience, rest assured that we'll try to tackle each and every question after this webinar if we don't talk about it now here in live. The first question I have here is about the deadlines again. So Mark, maybe just in a few words, can you just sum up again what the deadline for submissions of the application is? I know you had a slide on that, but just in a few words to recap for the ones who joined a little bit later.
Sure. Yeah. So if you have an entry that is unliquidated, right, which means it comes in on day one and it is open in Customs' system, that is eligible for CAPE. And so you should be submitting those in CAPE now. If any of your entries have liquidated, meaning they've become final within the Customs system, you would want to check how long ago they liquidated, because if it's within 80 days, you should still be submitting those entries into the CAPE system as well. But for anything that has liquidated and is beyond 80 days after the date of liquidation, then you're definitely going to want to be filing protests with U.S. Customs to preserve your right, because again, that is where the legal claim to a refund exists. It doesn't exist actually through case law or through the government's independent portal that they're developing.
Maybe just a quick clarification. It's not a genuine question from the audience, but can you just maybe elaborate also what is responsibility of the broker or the import of record, and what is the responsibility of an Austrian company who is not the import of record?
Yeah, if you are the customs broker would be the one that would be facilitating the importer of record in the United States filing the CAPE claim, but they are not legally responsible for the correctness of those claims, whether the HTS codes are correct, the value is correct, the country of origin. That responsibility still sits on the importer of record. So either the importer of record or the broker can file the CAPE declaration in ACE. But if you're an Austrian company and you were not the importer of record, unfortunately, you will not be able to file. You can obviously encourage your customers in the United States who were the importer of record to file the CAPE declaration. And then that kind of creates a different question about what you do with those refunds once they come back. But yeah, only importers of record or their broker can file.
Thank you. I think that's a very important piece of information here. When it comes to the import of records, obviously we also have smaller sized companies who work with UPS or FedEx or other forwarding agencies. How did this? How is the process working here? Can UPS or FedEx be charged directly, or will they be responsible for refunding companies? What is the process here, or what is the best practice you would suggest to our audience?
Yeah, so if you're having smaller shipments that are going through maybe a courier shipment, the question would be, who was the importer of record? Whose tax ID number was the ID that was used to file that entry? And if it was FedEx or DHL or UPS or one of these other companies, then they may be the importer of record. And so they would be responsible for making the filing. It depends on whose tax ID number the entry came in under. So you may want to raise those questions with UPS and FedEx directly. I think a lot of it would depend on what the quoted price was to you and whether it was DDP or whether it was DAP or whatever the terms were. But that's something you'd probably want to delve into a little more detail on, given the agreements between the parties.
So in that case, you would say reaching out directly to the shipping agency or to the forwarding agency, as in the import of record, would be the right next step.
Yes, that's correct. And just so
Perfect.
you know, Tomas, I know I went through a lot. I have a few minutes if there's some more questions, not a problem. So
Thank you so much. We really appreciate that. I would like to come back to one of the slides where you mentioned that an Excel file, CSV file has to be uploaded. Can you maybe give us more insights on how the template for this CSV file should look like, or do you have something on your hand?
I would have to download that through ACE. I think they do have an example. Once you log into ACE, customs had once, so I can, that's step one, regardless, is logging into creating a username and password in the automated commercial environment system, or ACE. And then once you're in ACE, you should be able to download a template directly from the website. I think it's kind of pre-filled or pre-programmed how customs would like that to look. But I can also ask around for some from templates from colleagues if they've got those. But you're definitely going to want to be using the format that customs gives you just to make it easier for them to issue spot those entries.
Thank you very much. Great. Let's see what other questions we have. We also have, okay, we dealt with that. We have a general question on, yeah, the Supreme Court ruling, the paid tariffs from imports from Austria are legal, right? So I think we can elaborate on that. You said in the beginning that all IEEPA tariffs were ruled out by the Supreme Court. So all the other tariffs at the moment, Section 232, Section 122, they are still in place. So you cannot generally say that all the tariffs on imports from Austria are illegal. I think you agree on that, Mark. The next one says, should we also protest after we filed in CAPE, although CAPE phase 1 does not cover protested ones?
That is a great question, and I'm glad that question came up because we discussed that internally as well. The question is, let's say you've submitted all of your entries in CAPE and they all were eligible at the time, and now you've kind of sat there and waited and waited and waited, and maybe customs hasn't issued a refund yet. Maybe they haven't approved your CAPE filing yet. But as those entries get older and time goes by, keep in mind that your only legal remedy to a refund under the rule of law would be to file a protest under 19 USC 1514 within 180 days of the date of entry. So I would be advising a client to be looking at those entries very closely and say, okay, once I've filed them in CAPE, you can't just go to sleep. You still need to monitor them and see how old they are, because if it starts getting to day 170, after liquidation, 175 after liquidation, and you still have not received an affirmable confirmation from customs or money being deposited into your account, I would be recommending a conservative approach would be to file a protest. You can always withdraw the protest if need be, but I still think you need to do what you need to preserve your legal rights under the law.
Thank you so much. We have another question here which says the manufacturer we source our goods from is responsible for paying the tariffs. Is that manufacturer were to receive, if that manufacturer were to receive a tariff refund, would we have any chance of claiming those back as their customer?
That's a great question. I think a lot of it is going to come down to intercompany agreements and how the prices were quoted. Some clients we have, it was very clear that they were passing on the tariffs to their downstream customers, and that if there was a refund or if there was a change in that, they would, pass those on as well or refund them in the same manner. Some of our clients, the price is $100 and that's it, right? There's no discussion as to what the tariffs are. So I think we're leaving customs land there. That's not really a customs question. That's more of an intercompany, commercial contract dispute between buyers and sellers as to kind of what's going to happen. So we're happy to take a look at those, but generally speaking, that's going to be dependent on your agreement and any writings that you have about how the prices were negotiated.
Perfect. I think we have a few more. So Mark, if you still had some minutes, I would like to go through them as well. It says, is there currently an option in the United States to obtain a tariff exemption for new specialized machinery and equipment that are being imported and cannot be manufactured in the US market? If so, when?
Currently, I do not believe that there is. That is something that I know that my colleagues in our Washington, D.C. office are really fighting for. The comment there is that if you want companies to invest in the United States, production in the United States, they should be able to move their machinery into the United States to be able to produce. That is something that the administration has not currently announced. They tease it a little bit with respect to pharmaceutical tariffs on the Section 232 side of things, that if you can start producing in the United States, but there's no official process right now to claim an exemption. But that is something that our government relations team in DC is working with mostly members of Congress and the administration to try to get opened up as a benefit to companies.
Yeah, and also it's worth mentioning that also we here in DC, we try to, push this this matter with USTR and Department of Commerce, and we have spoken to them, and they understand the problem, I think, but no solution was announced to this point. So as far as we know, there are no exemptions for industrial goods such as machineries or equipment, which is not produced within the US. But obviously, we'll keep you informed if something changes here. Mark, maybe two last questions before we come towards the end of this session. Regarding that template, you said it can be downloaded from ACE. A comment on that was that it is just like a very I don't see it right now, but it says that it's a very minimal template. So we would greatly appreciate if you could pass along maybe that template you have within Sandler, Travis, and Rosenberg so that we can share it as well with the audience.
Sure, I can see if I can get a copy. Someone did indicate that they thought it was one single column of just the entry numbers. And if that's the case, that's an easy process to do. But you want to make sure it's formatted properly as well. But yeah, I can try to get one.
Thank you so much. Much appreciated. And so, yeah, I have one more question here, which says, will the refund apply to the full amount or only a part of it? And will there be a value limit, as of your knowledge?
I mean, the refund should be tracked based on the indication of a specific Chapter 99 HTS code showing the IEEPA tariffs. And so that full amount, again, assuming there's no classification errors or country of origin errors or value errors or other things in that entry, Customs should refund the full amount of IEEPA tariffs that you paid. Again, they're kind of reversing the entry process and just removing the Chapter 99 number, which should recalculate what the normal duties would have been, right, if imported into the United States. So that would be your value times the most favored nation HTS code rate, the MFN rate. And if there's any other applicable rates. I mean, if there's Section 301 tariffs on those goods coming in from China, they're still going to be subject to the 301 tariff, but that's a different Chapter 99 number than the IEEPA tariffs would be. And so is there a limit? I would say the limit would only be what you paid, right? If you're probably not going to get more than what you paid in IEEPA tariffs, and there is a possibility that Customs, if they find an error, will try to deduct out what you owed them kind of out of their refund amount, just to make sure there's no over reimbursement for the tariffs.
Great. We have another question with a couple of thumbs up, so I'm gonna shoot that at you as well. It says, we have checked many documents from brokers and we have no information which ones are IEEPA tariff on it or not. Is the broker responsible to inform the DDP exporter on which ones are IEEPA and which ones are subject to other tariffs?
Yeah, I think it would depend on which report the broker is giving you. So some brokers don't have, I mean, some brokers have very technical reports, some have more limited. But at the end of the day, this is why I think it's really important to get your own ACE account, right? Because if you were the importer of record, that is going to be on file. You should be able to get a username and password and download all of your import data going back to February 1st of 2025. I think it's the ES003 report or the entry summary 003 report, but you're going to want to download that from February 1st of 2025 moving forward anytime. And then there's various Chapter 99 codes for the IEEPA tariffs, but you'd have to figure out which ones yours were, and then you could just filter the data by that. But your broker should have that information as well. It might not be in the specific report they shared with you, but generally speaking, they should be able to pull the same type of report out of their ACE account. Again, that would not be your ACE account, but that would be theirs, and they would be able to see your entries underneath that account as well.
Great, excellent. Mark, I think we have exceeded your time by far. Thank you so much for taking some extra time, going to the extra time, extra minutes for our audience. As you can see, this is really highly appreciated that you as an expert are taking this time. So thank you very much for giving us an overview and guidance on the question refunds. And yeah, thank you for being available for us also to tackle some questions which might drop in after this webinar. We really appreciate that. And yeah, for those questions we were not able to address during the session, we'll follow up on that after this webinar. Yeah, on a final note, for those of you who closely follow US trade policy, we also invite you to visit our US tariff information hub in German language called Zollinfopoint, available at wko.at. There you will find a concise overview of the current situation, along with links to the original primary sources. Yeah, with that, I would like to thank you all for the participation today at our Flash webinar. Once again, thank you very much, Mark, also for sharing your time and the expertise. I wish you all a wonderful day or evening, depending on where you are joining us from. All the best, and we hope to see you very soon. Best regards from Washington, and take care.